What is a statute of limitations in Seattle or Washington State? What does that mean? And what doesn't it mean? So if you've ever wondered what the statute of limitations means, this is the video for you. My name is Lance Fryrear. I'm a criminal defense attorney who owns a law firm in Linwood, Washington. We've been defending people charged with crimes for more than 20 years. And we often hear people talking about a statute of limitations, and it sort of gives people a false sense of security because sometimes it gets misused. So in this video, I'm going to cover three things. What does statute of limitations mean, and what doesn't it mean? Two, what are some common statute of limitations for crime types in Washington State? I can't cover them all because it's very complicated and there's lots of carve-outs and exceptions. And number three, what do you do if you've been investigated for a crime and you think that it's been a while? Maybe the statute of limitations might apply in your case. What do you do, and how might an attorney be able to help you? So again, I put these videos out for information to help people understand the criminal law because there's almost nothing out there that's just trying to educate people. So if you find this video useful, please like the video and please subscribe to the station because it'll get our message out to more people. Now I'm just going to jump right into things. So what does a statute of limitations mean? Well, think about it this way. The legislature and common law in general thinks that for most criminal acts, there needs to be a period of time where we can no longer be held responsible. So it's not over our head forever. It's a way to let, things in the past stay in the past. And so statute of limitations is a time frame at which point the prosecutor could no longer bring a criminal charge against you. So let's say that the alleged criminal act happened on January 1st of the year 2000. If the statute of limitations was 2 years, then after January 1st of 2002, so after that date, in most cases, in a 2-year statute of limitations, the prosecutor could not proceed with the charge. If they filed a charge, you could assert statute of limitations as a time bar to that prosecution. So that's what it means. What it doesn't mean, and a lot of people get this confused, let's say you get charged with a crime and the crime was taking a long time to prosecute. Let's say you went to court for the first time on January 1st of 2000, because it's easy to think about. Then the case took a while, or you were at a warrant or something like that. And now it's January 1st, 2005. It's 5 years later. So you think, hey, the statute of limitations is run. Well, no, it hasn't, because statute of limitations basically counts from the time of, limits the time to charge you. Okay, so if you're charged and it's within the statute of limitations, your charging date, then that no longer applies as a defense. So the case could take 5 years to 6 years, no longer applies. So that's often where people get confused. So moving on to number two, what are some common statute of limitations, and what are some common exceptions that sort of mess things up? Well, for a simple misdemeanor crime, think about it as it's a 1-year statute of limitations. There's not a lot of simple misdemeanors. That means 90 days in jail maximum, $1,000 fine maximum. But resisting arrest is a simple misdemeanor. Some fish and wildlife violations are simple misdemeanors. Other things you wouldn't expect to be simple misdemeanors are prostitution. There's a few others where the crime is a lower level misdemeanor. So that's 1 year for a simple misdemeanor. Gross misdemeanors, which are almost all misdemeanor non-felony crimes, it's a 2-year statute of limitations. Okay, that would be DUI, assault in the 4th degree, theft, 3rd degree. Things like that. Most driving a license suspended 3rd degree, reckless driving, all types of different charges have a 2-year statute of limitations. The majority of felonies have a 3-year statute of limitations, and there's exceptions to those things. I'll include a link in the description of this video that can go to the general statute. And then if you have a question, though, you need to talk to an attorney. And then sex offenses recently basically don't have a statute of limitations for most of them. Stuff like rape and molestation, things like that. The legislature's recently changed the law to say those can be prosecuted forever. And from a defense attorney's point of view, that's pretty scary. But, that's what the legislature says. And so obviously that's their public policy. So what are some exceptions? And most people don't know about this. Exceptions where the statute of limitations may not be running. So let's go back to that first example. The crime happens January 1st, 2000. Let's call it a 2-year statute of limitations. And the prosecutor doesn't get around to charging it until March 30th, 2002. So that's more than 2 years later. So, hey, they charge the crime. They go into court and say, we have a defense. The statute of limitations is run. Well, if you were out of the state and not subject to prosecution to the jurisdiction of the prosecutor, and the prosecutor knows about it, well, then that sort of tolls the time. So if you were living in Iowa for a year, therefore they couldn't prosecute you, and they can prove you were living in Iowa for a year, well, then that adds another year to the statute of limitations. So it's real important you talk to an attorney and don't start going into court without an attorney, because you might say some things that end up letting them still be able to prosecute you. Another exception to the statute of limitations can be COVID. COVID-19 is an exception, right? We did a blog about this. Basically, the governor has extended the statute of limitations, and they're still subject to litigation on that, extended it because the courts were closed for a period of time. And therefore, if you're being charged, I would guess, between 2020 and 2025, depending on how things turn out, there's going to be some wiggle room in the statute of limitations, okay? And so you need an attorney. If the case has been hanging around for a while, you definitely need an attorney. And another exception can be for certain types of theft crimes and things like that, discovery of the fraud, maybe when the statute of limitations starts to run, as opposed to when the offense actually happened. And so it gets complicated, but in general, those are exceptions. So the third thing that I wanted to cover here is, if it's been a while and you've been, contacted by police or arrested and you think the statute of limitations might be coming up, what do you do, right? What do you do about it? Well, the first thing you want to do is get a hold of an attorney. Let the attorney look at what the situation is, look at what really applies, and let the attorney do some research. You don't go calling the prosecutor's office and say, hey, am I out of the woods yet? I think my time's about up, because guess what? You don't know how to do that right. And the prosecutor may say, oh, thanks for mentioning it. Yeah, we're going to get to your case now and charge you with the crime, right? So don't do that. Let an attorney try to figure it out. Also, if it's been a while, you might want an attorney to try to help see what's going on sort of behind the scenes. Get the police reports. Use their knowledge and experience to find out how to inquire without ringing any bells, to see maybe the case has already been declined. Maybe the prosecutor made a decision at the 6-month mark not to prosecute you, and you've been waiting 2 years for no reason. So contact an attorney to try to help you with that. So if you think it's coming up, that's what you need to do. Now, if it's a juvenile case, we're not talking statute of limitations. If it's a juvenile case, the juvenile court loses jurisdiction over a juvenile once the juvenile turns 18. If you were 17 when you did something and the prosecutor charges it after you're 18, it's no longer in juvenile court. So for juveniles, it's not exactly statute of limitations, but it's similar. You need to get an attorney right away to make sure cases get handled while you can still maintain juvenile court jurisdiction. So I hope you find this useful. It's more confusing than you would think, right? If so, please like this video. Please subscribe to our channel so we can get the information out there to more people. And if you find yourself in the situation where you at all suspect you might need criminal attorney help, please give our office a call. We'll listen to what happened. We'll try to decide if we can offer some help. If so, we'll do everything we can, and we'll be there for you. Thank you.